Oil is oil, right? I mean, here is a gallon of groundnut oil, and here is a gallon of engine oil. Oil is oil. However, can you imagine pouring groundnut oil into your engine? Or will you fry egg with engine oil like they are doing in that video right there? If you see that egg, will you eat it? Because, I mean, oil is oil. I'm sure you know now that oil may be created equally, but all oil is not the same. In the same way, all land documents may be legit, but some land documents are more equal than the others. And in this video, I'm going to be sharing with you 5 land documents which are legitimate but do not secure your property for you and also do not have the power to transfer legal ownership to you. And if you stay with me to the end of this video, I'm also going to be sharing with you 5 legal documents that secure your property and at the same time transfer legal ownership to you. Are you ready? Here are 5 documents that don't have power to secure your property or to transfer legal ownership to you. Number 1 is land receipts. Land receipts only prove payment, but they do not confer ownership. They are not legal titles. Number 2 is survey plan. Survey plan shows you the exact location and size of the property, but it does not confer ownership. In other words, it is good to have, but it does not prove that you own the land. Number 3 is community receipt or family receipt. So you bought that property from a family or from a community, so they give you a receipt. But having that receipt does not confer ownership on you. Legally, it still doesn't prove that you own that property. Number 4, power of attorney. Now, this is a bit dicey, so pay attention. Although the power of attorney gives you power or authorizes you to act on behalf of the original owner of the land, it does not legally confer ownership to you. Yes, there is also the irrevocable power of attorney, which implies that the person that sold the property to you does not have the right on his own to revoke that authority that he has given you. However, sometimes this can be contested in the court of law. So, although it can give you the power to exercise authority over the land, however, it does not confer legal ownership on its own. That is why, of course, you have to join it with something else. Number 5 is contract of sale. Contract of sale is just an agreement between a buyer and the seller. However, it does not confer ownership on you. Now, the real question you are asking is, if all these things do not prove that I own this property, which documents do I need to get that will now prove that I am the real owner of this property? There are 5 documents I'm going to be sharing with you. You don't need to have all of them. However, if you can combine one of these documents with 1 or 2 from the other ones that I've shared before, it's all over. Now, that doesn't mean that you should be combining groundnut oil and engine oil. No, this is just for land documents. Are you ready? Number 1 is certificate of occupancy or CFO. This particular document is so powerful that it actually has the power to protect you from all legal disputes, and sometimes it can even protect you from government takeover. So if the government has to take any land, they have to compensate you. That's how powerful it is. Now, the CFO is the highest form of land title in Nigeria. That's certificate of occupancy. Number 2 is the deed of assignment. The deed of assignment is a legally binding document that transfers ownership from the seller to the buyer. However, the deed of assignment must be stamped and sealed at the land registry or the Ministry of Lands before it can be enforceable and legally binding in Nigeria. Number 3, deed of conveyance. The deed of conveyance has the same status and the same power as the deed of assignment. So the deed of conveyance has everything the deed of assignment has. In other words, it is a legally binding document that transfers ownership also from the seller to the buyer. Number 4 is the grant of probate or letter of administration. Now, here is how it works. Normally, your father gave you a property and you inherited it, you still need to get a grant of probate or a letter of administration from the government for it to be legally yours, for it to be enforceable, so that nobody can take it from you. So a grant of probate or a letter of administration legally transfers ownership from the owner of the land to the person he wants to inherit the land. Number 5 is a governor's consent. And this particular consent must be combined with deed of assignment. Now, here is how it works. You may not have heard it before, but if you are buying a piece of property from someone that already has certificate of occupancy, you must get governor's consent to be able to transfer ownership from the person that owned it originally, who had it registered in their name. So for it to be transferred from that person who is the seller to you, the buyer, you have to get a governor's consent. So these are the 5 documents that are legally binding, that have the power to transfer ownership to you. 1 is certificate of occupancy, 2 is deed of assignment, 3 is deed of conveyance, 4 is grant of probate / letter of administration, and number 5 is governor's consent when it is combined with deed of assignment. Now, talking about deed of assignment, all our properties here always come with deed of assignment, because we understand how important it is for you to have legal documents that transfer ownership to you. For example, is the Castle View Estate. The Castle View Estate right here in Owo, Enugu State, is currently going for 5 million naira, and it comes with the title of deed of assignment, and also, of course, with a survey plan. Like I said, you have to combine some of these things. All right, so once again, my name is Toby Nwazo, and I'm your real estate investment guide and your financial investment guide. And all you need to do is to call or send a WhatsApp message to the number showing right there on your screen if you have any real estate needs, especially in Enugu State. Bye.